The case that I chose for my speech was Miller versus California, which took place in 1973. This was a case that was fought primarily over the issue of obscenity, and it also debated whether certain materials could be considered obscene and whether or not that gave them protection under the First Amendment. So this case focuses primarily on the issue of obscenity, but about 6 years earlier, in 1966, there was another case called Memoirs versus Massachusetts, and this also took place over the issue of obscenity. The court actually ruled that material is considered obscene if it lacks any redeeming social value. This would come into play later on when Marvin Miller took his case to court. So in 1971, a man named Marvin Miller from California owned a small mail-and-order business, and basically what he did was he would mail out pornographic magazines. He would send out advertisements for pornographic magazines, and he would send these to random people across California. And there was no law back then prohibiting him from doing so, so he thought he was in the right for doing this. So one of the people that actually received one of the ads that Miller was sending out was an owner of a restaurant in Newport Beach, California. And when he received the ad in the mail, him and his wife opened the package to find some sexually explicit images of a man and a woman engaging in intercourse. And it's safe to say they were pretty disgusted by it, and they thought they should do something about it. So they decided to sue Marvin Miller for distasteful distribution. And keep in mind, there was no law in the state of California before this that prohibited Miller from sending out obscene material. So, in his eyes, it was all legal. So, the restaurant owner and his wife took Marvin Miller to court, and they charged him with knowingly sending out obscene material, which under the California Penal Code is illegal. Marvin Miller argued that the jury, which found him guilty, did not use the same standards that were used in Memoirs versus Massachusetts, and he also said that material cannot be considered obscene if it has redeeming social value, as stated earlier. The court pretty much denied his appeal. They said he was guilty, and basically they said from now on, if you don't follow three specific criteria, then your material can be considered obscene. And these criteria include whether the average person who would find that work taken as a whole appeals to elude curiosity, whether the work depicts or describes in an offensive way sexual conduct or excretory functions, whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. So essentially, if you're sending out material and it fits the bill for all three of these criteria, it's considered obscene, and therefore it is not protected under the First Amendment. And in that case, you could get sued and you could get charged. So, how does this case apply to our world today? Well, essentially, anyone can be a producer and distributor of their own content. Um, if you are putting out material that could be considered obscene or maybe more adult friendly, you could get in some trouble. There are certain websites for that. Um, there are certain areas of the digital age where you are free to express yourself, but in the public domain, most people aren't going to accept that type of material. And Marvin Miller definitely thought that he could get away with sending out pornographic images, and the court clearly proved him wrong. So this shows that you can't just go sending anything to anybody. It has to have some sort of social or emotional or political taste. I think it has to have something to say in addition to that. Um, yeah, if you are a producer, you should probably consider looking over the three requirements set by Miller versus California um, that decide whether something is considered obscene or not. I think a lot of people in this country have this idea that the First Amendment means you can just say anything you want and there will be no repercussions. And I think this case proves that there clearly are some standards and people do care about what you say. So I think to have some caution and to have that foresight is very important when it comes to putting out your own content.